topic, why you shouldn't handle your own injury case, I think almost kind of speaks for itself, doesn't it? You have a lot of people out there, and I think this isn't to blame people that think that they can do it. You think about what you see all weekend long on TV. You see happy-go-lucky insurance company commercials with emus and people wearing white aprons and funny jokes. And I think people see these commercials and they're inundated with this nonstop, and they think, you know what, I got rear-ended, I'm hurt. I've seen these commercials, the insurance company is going to do the right thing, and that's about where it ends. One thing I tell people all the time is if insurance companies did the right thing, I'd be unemployed. So that's why they don't do the right thing, and that's why you need someone to help you through that process. And it's not only one thing or one thing here, one thing there. It's literally a minefield. I wouldn't even say it's a pitfall because that's just one hole. There's literally multiple mines you can step in this field if you try to go it alone. And one of the first things you'll see happen is, we're so sorry you're hurt. We want to help you through this, but do you mind if we take a recorded statement? Because we'd like to hear your version of events. That's clearly just trolling to see if you say anything that gives them an out to say, whoa, wait a minute. Maybe we didn't cause this collision. Maybe you were speeding. Maybe you ran the red light. Maybe you went left to center. Or maybe you didn't have your seatbelt on. They'll go further. Were you doing anything on your phone? Were you distracted? Did you have anything to drink that day? Did you take any prescription medications? And it's in those recorded statements. I've read plenty of them where you can kind of see the injured party saying, wait a minute, why are we talking about me? We're spending a lot of time talking about what I did, and it seemed your guy was the one that ran the red light at 60 miles an hour in a 35 mile per hour zone and T-boned me. Why are we asking about my medical history? What typically happens is, from the date of the injury, there's what's called a 2-year statute of limitations. And what that means is basically you either settle your case with the insurance company within 2 years of the date of the collision, and if you can't settle the case, you have to file a lawsuit within that time period. If you don't file a lawsuit in court within that 2-year time period, your case is forever over. You're out of time. Time expired. And what will happen a lot is you'll see someone try to do it on their own, and they will come to us at the 11th hour, 3 weeks before their 2-year statute of limitations. And what am I looking at? I'm looking at what should have been an open and shut claim, but this person went and thought the insurance company's got my best interest at heart, so I will do a recorded statement. Or they want to get my past medical records, so I will sign an authorization and allow them to go dig around with every doctor I've ever seen. Okay, and the next thing you know, the insurance company's taken a stance that maybe we don't owe you anything anymore. And now they're standing there with a file of papers about 2 feet tall, and they've gotten no further than they were when the collision happened 2 years earlier. But what doesn't happen throughout that entire process is any monetary offer. So the injured party bends over backwards for 2 years during this process, trying to give the insurance company everything that they want to help evaluate the claim. And then they're a few weeks away from their statute of limitations, and they've got a filing cabinet of paper for this claim, and they have $0 on the table for their injury claim. And then they're in very dire straits at that point, because now they're trying to find an attorney that wants to take their case on 23 months in. It's why we stress again, the earlier that someone can get into us allows us to kind of get ahead of the ball and start controlling what information comes out from our end, while we can start feeding them information that we think strengthens our claim. Someone that's been in an accident is scared, confused, and they realize very quickly that there's no such thing as just a typical fender bender, or there's no such thing. It's an accident, it'll all work out. What they quickly realize is, my phone's exploding. My phone, I'm getting phone calls. I don't even know who's calling me. I'm getting phone calls from the insurance company of the person that hit me. I'm getting phone calls from the insurance company of a passenger that was in my car. I'm getting phone calls from my own insurance company. Then the phone calls from lawyers start. And now I'm getting texts from law firms. I'm coming home and there's something hanging on my doorknob, magnets and photos of law firms. We don't do any of that. Instead of going around hanging things on people's doorknobs or sending texts to potential clients, we rely on our reputation from past clients. We want to get you in, we want to sign you up, and I want to tell you, go worry about your medical treatment. The legal side of this, the claim side of this, should follow the medical treatment. You've got enough to deal with your health insurance, your doctors, getting the proper treatment. Let me take all of this away from you. And you're no longer talking to insurance adjusters. You're no longer talking to defense attorneys. You're no longer talking to the other side. We send letters of representation out that say, do not contact this person anymore. Any question you have regarding this claim should go through me. That allows me to kind of serve as the first line of defense as to what information is going to go out to the insurance company, what information that if I'm sharing something with them, I think that they should reciprocate and provide me some information, and I kind of stand as a firewall. We stand as a strong firewall between the insurance company and our injured client.